Hello and welcome to the YouTube channel of Vidhi Culture. We are again here with the legal updates of 27th July 2022. And today we will discuss a very important case which is coming out from the Honorable Supreme Court. And this case is Vijay Madan Lal Chaudhary versus Union of India. So this is a very important case with respect to the the provisions of PMLA, Prevention of Money Laundering Act. It is very important judgment because a lot of petitions, more than 240 petitions were filed in the court with respect to different provisions of the PMLA, and this was a combined hearing of all those petitions which was filed before the Supreme Court, and it has been heard by the Supreme Court, and the final decision has been made, and it has been a hot topic of today because a lot of talk and debates has been started after this particular judgment, and how it will have different repercussions on the ongoing cases which are the ongoing cases, and जिसके अंदर की ईडी जो है वो इन्वेस्टिगेट कर रही है. इट विल हैव अ लॉट ऑफ इम्पैक्ट ऑन दोस केसेस व्हिच आर गोइंग ऑन इन द कंट्री राइट नाउ. So let's look at the judgment being pronounced by the Honorable Supreme Court. So this case is Vijay Madan Lal Chaudhary versus Union of India. So in this case, what Supreme Court has done, the Supreme Court has upheld the validity of provisions of the Prevention of Money Laundering Act. तो यहाँ पे PMLA के जो provisions थे जिनको यहाँ पे challenge किया जा रहा था, it has been upheld by the Supreme Court. So Supreme Court has denied the arguments made by the petitioners here in that case, that it is arbitrary and it is unlawful, all these things, so that those arguments have been set aside, and the Supreme Court upheld the validity of the provisions of the PMLA. यहाँ पे PMLA के जो provisions है उसको यहाँ पे Supreme Court ने upheld किया है. Then Supreme Court also held that a person cannot be proceeded against the PMLA unless a FIR has been registered in the respect of predicate offense and or a case is awaiting trial before the competent forum. तो यहाँ पे ये बहुत ही इंपॉर्टेंट बात बोली है सुप्रीम कोर्ट ने. सो हेयर अ टर्म इज यूज्ड दैट इज द predicate offense. So what do we understand by a predicate offense? So predicate offense is nothing but it's a crime that is a component of a more serious crime. So it is basically a component of a more serious crime. It is also a crime and it is part of a very serious crime. And the examples of such is the like money laundering, terrorist financing, all these things are called to be the predicate offenses. Then what next the Supreme Court has said in this particular case is that the court has upheld the two provisions of the PMLA Act which was challenged in this particular case, that was section 45 and section 50. So firstly, the court upheld the section 45 of the PMLA which makes the offenses to be cognizable and non-bailable. जो यहाँ पे cognizable बनाता है उसको non-bailable बनाता है, and no person accused of an offense shall be released on bail or on his own bond unless the public prosecutor is given the opportunity to oppose the application for such release. तो यहाँ पे ये प्रोविजन जो है वो कहता है that no person shall be released on bail. यहाँ पे बेल भी नहीं मिलेगी unless the public prosecutor has been given a chance to oppose that application, that bail application. उससे पहले यहाँ पे बेल भी ग्रांट नहीं की जा सकती है. This provision was challenged before the court, but the court has upheld this provision in this particular case. Then the next section which was challenged in this particular case that is section 50. It has also been upheld. Court also upheld the section 50 of the PMLA, which says that statements made by accused to ED, that is Enforcement Directorate, are admissible. सो कोर्ट हैज सेड दैट जो 50 सेक्शन 50 है वो बात करता है कि भी जो भी स्टेटमेंट ईडी के समक्ष दिए जाएंगे वो सभी कोर्ट के अंदर एडमिसिबल होंगे, ऐसा सेक्शन 50 कहता है. बट व्हेन वी रीड आर्टिकल 20 सब क्लॉज 3 ऑफ द कॉन्स्टिट्यूशन, इट सेज दैट नो पर्सन अक्यूज्ड ऑफ एनी ऑफेंस शैल बी कंपेल्ड, कि भाई किसी भी अक्यूज्ड को कंपेल नहीं कर सकते हैं अपने ही खिलाफ विटनेस बनने के लिए, अपने ही खिलाफ गवाही देने के लिए. वी कैन नॉट, द पुलिस फोर्स और एनी फोर्स कैन नॉट हैव दिस काइंड ऑफ थिंग कि भाई उसको खुद ही फोर्स किया जाए कि आप अपने खिलाफ जो है डिसीजन, मतलब अपने खिलाफ ही जो है वो विटनेस बने और अपने खिलाफ ही ऐसी चीजें बताएं जो आपके ही खिलाफ जाती है, उसके लिए फोर्स नहीं किया जा सकता है. ये 20 सब क्लॉज 3 कहता है हमारे कॉन्स्टिट्यूशन का. लेकिन यहाँ पे इसके बावजूद भी यहाँ पे सेक्शन 50 को यहाँ पे जो है जो वैलिड माना गया, अपहेल्ड किया सुप्रीम कोर्ट ने, ये कहते हुए दैट इट इज अ different case altogether. It will not be covered under 23 because it is not actually, not actually an investigation like, done by the police for that matter. As it is done by the police, तो वहां पे ये हो सकता है, but it is not that case. तो यहाँ पे जो है, यहाँ पे प्रोविजन को अपहेल्ड किया गया है. Then further, it was stated that supply of a copy of enforcement case information report, like that is ECIR, to the person concerned is not mandatory in every case. Then one more controversial provision which was there, that it is not required to give the copy of the ECIR to the person concerned. Concerned person को देने की जरूरत यहाँ पर नहीं है हर केस के अंदर. अगर ईडी चाहे तो ना भी दे, तो इट कैन नॉट बी चैलेंज्ड कि भाई कॉपी नहीं दी गई है ईसीआईआर की. So this is also one of the provision which was challenged, but it has been stated that it is absolutely correct. So यहाँ पे साफ साफ कह दिया गया कि भाई it is not mandatory in every case. Then the court also said that it is enough if ED at the time of arrest discloses the ground of such arrest. अगर सिर्फ जो है ground of जो आपके अरेस्ट हैं, अगर वो सिर्फ उतना भी बता दे, then also it is more than enough and that is enough for the arrest. So ED can arrest, just by disclosing the grounds of such arrest. The copy is not actually required. You cannot force them to give the copy, or you cannot challenge this thing if the copy is not given to you. अगर आपको कॉपी नहीं भी दी जाती है, then also you cannot challenge your arrest. आप उसको जो है चैलेंज वहां पर नहीं कर सकते हैं. तो you cannot challenge this thing in the court अगर आपको कॉपी नहीं भी दी जाती है वहां पे. So this is very, very important case with respect to your exams. Also, this may be asked in many competitive exams. If some recent judgment has been asked, then it is a very landmark and an important judgment which you must keep in mind. That is, which is very, very important for the examination. So this case is Vijay Madan Lal Chaudhary versus Union of India 2023. So please remember this case whenever you are going to write any kind of exam. It is very, very important. So I hope you all have understood this particular case, the highlights of this particular case, and what are the important things in this particular judgment. I have already told you. So thank you so much. Thank you for joining. I'll see you in the next video of the legal update. Thank you so much. Thank you for joining.